there.
There you are. All right, if you're going to testify this morning, if you'll raise your right hand, please.
Do you solemnly swear or affirm the testimony you're giving today is true and correct, so help you God?
I do.
I do.
Let me put your hand down. And cause number 15, the state of Jason Dunlap Brown.
Can I pay you for the for Pearl Elizabeth Brown, the dependent administrator of this estate?
All right, you may proceed, Counselor.
I'm sorry?
You may proceed. Are you
Okay.
Mr. Biggie?
Yes, yes.
There's so
This
many
is-
screens on the computer. I can't see. I can't hardly tell where anybody is.
Okay.
But go ahead.
All right. We have two applications for the court here, an application to ratify distribution of estate property. This is, I should explain what happened. In January 2020, the applicant in her individual capacity traded in a vehicle. That was a 2012 Ford. That was community property of the estate. So the estate had a 1/2 interest and she had a 1/2 interest, and she traded that in. And so it's property that she would have gone to her in any event. And so we're just asking the court to ratify that distribution.
So done. Thank you, Counselor.
I'm
Anything
sorry.
else?
Yes, then I have an application for partial distribution of the estate. This is for a partial distribution. This is for a distribution of the home, which is community property, and all of the miscellaneous personal property that's in the home that's part of the estate, just tangible personal property, to Pearl Elizabeth Brown. This is all community property, so we're just asking that the court authorize the distribution of those assets to her. This will have the effect of leaving the liquid assets in the estate account as the sole remaining assets in the estate.
Anything else?
That's all, Your Honor.
All right. So I'm granting the application to ratify distribution of the state property. Thank you, Counselor.
Thank you, Your Honor. Can be excused.
Maybe. All right, cause number 70, the state of Jerry D. Hood. Mr. Mayo, good morning.
Good morning, Your Honor. We got so many people on there, I need to check and see if my witnesses have all appeared. Is that okay, Your Honor?
I know.
Is Darlene Mitchell with us?
Yes.
Okay, I didn't even see you, but you're here. Okay. Is Laura Witcher with us? No Laura Witcher.
Laura? No. You want to make a call
I'm
and come back to you're
I'm
there?
here.
Where are you?
I was
And
muted.
okay. That problem is Rachel Lee Cummings with us?
Yes, I am.
All of my witnesses are here, Your Honor, so I can go proceed.
Okay, will you turn your
I'm sorry,
there
Your
you
Honor?
are. I want to be able to see them. So
Okay.
I think you're all on now.
Okay.
Camera on is what I was trying to say.
Yes, sir.
All right, I think you can see.
All right. Your Honor, I would call Rachel Lee Cummings. Ms. Cummings, is it true that Jerry D. Hood died on April 22nd, 2025 in Baytown, Harris County at the age of 65 years and 4 years have not elapsed since the date of her death? Ms. Cummings?
Yes.
Okay. Was she a resident and had a domicile and fixed place residence in Chambers County on the date of her death?
Yes, that is correct.
The document that we filed with the court dated April 15th, 2025, purports to be her last will and testament, was never revoked so far as you know.
That is correct.
A necessity exists for the administration of her estate, is that correct?
Correct.
And no children were born to or adopted to her after the date she executed the will, is that correct?
Yes, correct.
And the decedent was never divorced after the will was executed, is that correct?
Yes.
The will does not name the state of Texas or an agency of the state or a charitable organization as a devisee in the will. Is that correct?
Yes, that is correct.
And you, Rachel Lee Cummings, named an executor of the will to serve without bond, are not a convicted felon. You're qualified to serve and not disqualified for lawfully accepting letters of testimony, and you're entitled to such letters. Is that correct?
Yes, that is correct.
That's all we'd have of this witness, Your Honor. I
Right.
would call,
Are you next
I would-
witness?
I would call Miss Darlene Mitchell. Ms. Mitchell, you there?
Yes, I'm here.
Okay. Ms. Mitchell, you were there on the day this will was signed. Is that correct?
That's correct.
And we have filed a copy of the will with the court, and that will has your signature on it. Is that correct?
That's correct.
And on the date that that will was signed, you were over the age of 14 years, and so was the other subscribing witness, and the testator was over the age of 18 years and was of sound mind. Is that correct?
Yes, that's correct.
Now, this is a copy of a will, and we have a presumption possibly if we can't produce the original that the original will was destroyed. But is it true that upon the execution of the will that you yourself took custody of the original will? Is that correct?
Momentarily, yes.
Okay. And is it true that the decedent was in the hospital at the time the will was signed, so she never had possession of the will? She moved into an assisted living environment and passed away within about 2 days. Is that correct?
That I didn't have knowledge of, but she was in the hospital at the time.
Okay. And you didn't leave the will with her in the hospital?
No, I
Is that
did
correct?
not.
Okay. That's all we'd have of this witness, Your Honor.
Are you next witness, Counselor?
I would call Miss Laura Witcher.
You can go.
Miss Witcher,
If you
is
want.
it true that you were the person who typed up this will?
Okay,
Make sure.
okay.
And as such, you had talked to the decedent about her will and were familiar with what the terms of the original will were. Is that correct?
Correct.
And the will we filed with the court, which we've shown you a copy of, is a true and correct copy of the will that you typed that was later executed by the decedent. Is that correct?
Correct.
Your Honor, that's all we'd have. We would rest.
If I admit the will to probate and grant a letter of testamentary. Thank you, Counselor.
Maybe excuse, Your Honor.
Maybe.
Thank you, Your Honor.
All right, cause number 71, the state of Clarence, Alan Barra.
Thank you, Judge.
There you are.
Yes, sir. I see the applicant, but I do not see the other two witnesses. So I need to call and see if they're on, Judge.
Okay, if you want to do that, and we'll come back to you.
No, I'm just saying now I could just get them to announce.
Oh, okay.
Yes, sir. Ms. Kniff, are you there?
Shelley Kniff, I see her. Shelley? There she
She's
is.
here, Judge?
Yeah.
must
There
be
she
muted.
is.
Sure.
All right, what about your other witness?
Miss Patricia Sutton. Perfect. Can you turn the microphone on, please? You hear us?
Do you see
Yes,
her
sir.
on, Counselor?
Yes, sir, Judge. There she
Okay.
is. Thank you, Judge. And we have a affidavit of heirship on file and an administration, application for administration. And so if you're ready, we
You may
also,
see.
do you see Miss Clapper, Judge?
Miss Clapper's on. I saw her earlier.
I'm here.
There
I'm
she
here.
is.
Perfect. Thank you, Judge. May I proceed?
You may.
Mr. Barrow, can you please state your name for the record?
Yes, sir. Tricia Sutton Barrow.
No, ma'am, I'm gonna call Mr. Chris Barrow first.
I'm here.
Mr. Barrow, can you please state your name for the record?
Chris Allen Barrow.
Yes, sir. Did you file a sworn application to determine the heirship for the decedent?
Yes.
Do you think it's in the best interest of the estate for the court to determine who are the heirs and only heirs of the decedent?
Yes.
This court that's determining the heirship is the same court that's doing the administration, correct?
Yes.
So you listed 3 heirs. I'm going to start with Bobby T. Barrow. What is her relationship to the decedent?
That's my dad's wife.
And they were married at the time of his passing.
Yes.
And her real and personal property interest in the estate would be 100%, correct?
Right.
And then you are Chris Barrow, correct?
Yes, sir.
What is your relationship to the decedent?
That's my dad.
And you will take zero real or personal property from the estate, correct?
Right.
And there's another heir listed, and that's Dean C. Barrow. What is his relationship to the decedent?
That's my brother. That'd be his other son.
And he would also take zero from his real and personal property, correct?
That's correct.
And then this list of heirs that we just discussed are all of your father's living children. And there were no other children that predeceased your father, correct?
That's correct.
And at the time of the death, you said Bobby Barrow was your mother, and she was married to Mr. Barrow. And there was no other marriages that your father had except for to your mother, Bobby T. Barrow, correct?
Correct.
There were also no other children born or adopted that haven't been listed in the above. And they were all the heirs listed above, all the children listed above, were from that marriage, correct?
Correct.
Now, to the best of your knowledge, did your father pass without a will?
He said he had one.
But you guys can't locate it, correct?
Yes, sir.
Now, does this application omit any information required by the Texas State Codes, or you've included all the information?
I included all the information that I know.
Yes, sir. Does this application contain all the material facts and circumstances within your knowledge and information that shows the time, place of death, and the names of all the heirs to your father?
Correct.
You asked that the judge determine the heirship, correct?
Yes, sir.
I have no further questions for this witness, Judge.
Good morning.
Good morning, Judge. Chris,
Uh-huh.
how are you today?
Good. How you doing? I'm old school
I'm
teacher.
good. Yes, for sure. It is a sadness that your dad has died, and the fact that your mom is so ill.
Right.
But it's good that you're willing to step up and do what you and your brother need to do for your mother, who
Right.
is the 100% heir of the estate
Right.
at this point. They were
Right.
only married one time during their lifetime, and that was to one another, correct?
Right.
And the children, you and your brother Dean, the only children born to or adopted by your parents during his lifetime, correct?
Correct. Mhm.
And there's no other person who's just come out of the woodwork and said, "Hey, I'm kin to Chris
No,
and
ma'am.
Dean," and
No, ma'am.
there's not even a rumor of such to your knowledge, correct?
To my knowledge, no.
All right. And you have asked the two witnesses who know your parents and have known them for so long to confirm just about everything you just said, aren't you?
Yes, ma'am. Yes,
All
ma'am.
right. So Pat Barrow Sutton, who's beside you, is that correct?
That's correct.
And then the other knowledge with knowledge is Shelley Leger Cuniff from Winnie, correct?
Yes, that's correct.
Well, I, as the ad litem, have been appointed to look at marriage certificates, divorce papers, go through all of the known heirs and locations to see if anyone else had claimed to be a child of or an heir of your dad. And I was not able to find such. So thank you very much for stepping up to do this.
Yes, ma'am.
Pass the witness, Your Honor.
All right, Ms. Chandler, call your next witness.
Call Miss Sutton.
Yes, sir.
Yes, ma'am. Could you please state your name for the record?
Patricia Barrow Sutton.
Yeah.
Yes, ma'am. Did you personally know Mr. Clarence Barrow?
Oh, yeah, since I was about 16.
So you've known him a good long while.
Oh, yeah, he was my
Did-
brother-in-law.
did you come to know that he had passed in April of 2021?
Yes, sir.
And did you know his marital relationship?
Oh, yeah. They were only married to each other all their life, pretty much.
And did you also know that he had 2 boys of that marriage?
Yes, sir.
Do you know of any other children or any other heirs that
No.
he may have had during his
No,
lifetime?
sir.
Were
No.
there any other children born or adopted during that marriage?
No, sir.
Now, are you an heir to this estate?
No.
I have no further questions, Judge.
Piper.
Yes, Patricia, it's nice, Pat, I'm gonna call you Pat. Is that
Yes,
okay
ma'am.
with you?
Yes, ma'am.
Good. It's good to see you this morning.
Good to see you.
You and I have spoken before today,
Yes,
and
ma'am.
everything that you've testified to today, you and I discussed.
Yes, ma'am.
And the more important is nobody's promised you anything to come here to testify and tell what you know of Mr. Barrow.
Oh, no,
But the
ma'am.
fact that and it's all true and correct.
Yes, ma'am.
Thank you so much for being here.
Yes, ma'am. Thank you.
Call your next witness, Counselor.
Call Ms. Kniff, Judge.
You may proceed.
Ms. Kniff, could you please state your name for the record?
Kelly Leger Kniff.
And how long did you know Mr. Clarence Barrow?
Oh, I think I met him when I was 9. So
So, a
45 years.
so a good long while.
Yeah.
And you also too knew his familial relations, correct?
Yes.
You knew that he was only married to her for his entire adult life.
Yes, sir.
And you also knew that he only had 2 children, and it was the boys, Chris and Dean.
Yes, sir.
And you also are not an heir to this estate, correct?
No, sir.
And you weren't given anything to come testify. No one offered you anything to come testify. This is just what you know of the family relations.
Correct.
I have no question, Judge.
Ms. Knipp, you and I have spoken before today, correct?
Yes, ma'am.
And we went through all of these areas. And you don't know of anybody out there who's claiming to be an heir of Mr. Barrow or Mrs. Barrow, other than the 2 boys that are now in the records on this case, correct?
Correct.
And nobody's promised you anything wonderful for you to come here today to testify.
No, ma'am.
Thank you so much for being
You're
here.
welcome. Thank
Pass
you.
the witness, Your Honor.
All right, Counselor.
Yes, sir, Judge. If you determined heirship, then I'd like to proceed with Mr. Barrow again, Mr. Christopher Barrow.
Piper, I see you signed off on the judgment declaring heirship, so you agree to it.
I do, Your Honor.
Have
do.
you all agreed to a fee, deadline fee?
I have done a sworn statement for $511. The $11 was additional cost for the things I had to get in the discovery. So that's what I'm asking for.
Okay, I'm gonna approve the judgment declaring heirship and the $511 to be paid to the ad litem. You may proceed on the administration, Counselor.
Sir, Judge, I'll recall Mr. Barrow. Mr. Barrow, can you please restate your name?
Chris Allen Barrow.
Are you the applicant to file for the independent administration and the issuance of letters of administration in the estate of Clarence Allen Barrow?
Yes, sir.
Did Mr. Barrow pass on April 12, 2021 at the address located at 1215 Texas 124 in Winnie, Texas, which is in
Yes, sir.
Chambers County?
Yes, sir.
Was he a resident of Chambers County?
Yes, sir.
How long had he been a resident of Chambers County?
All his life.
And you had testified earlier that you thought he had a will, but none of you were able to locate the will. So he in fact did pass without a will, correct?
Yes, as far as I know, that I know.
Yes, sir. Has citation been served and returned in the manner and for the length of time required by Texas State Code and evidence in the court's file?
Yes.
The necessity exists for the administration of this estate.
Yes.
Was Mr. Barrow married at the time of his passing?
Yes, sir.
And you had testified earlier that he had never been divorced, in fact, and that he and your mother had been married their entire adult life.
Yes, sir, that's correct.
And if you don't mind me asking, how long were they married?
Uh, 50, let's see, I'm 60, it could be 63, so they were 57, 68, 58 years.
That's absolutely spectacular. Now, does the necessity exist for the administration of the estate?
What is that again?
Is there a necessity that exists for the administration of this estate?
Uh, I don't understand that question. Yes,
Yeah, you need the administration so you can handle
yes,
business on
yes.
behalf of the state. Have you ever been convicted of a felony or otherwise disqualified by law from accepting letters of administration
No,
or
sir.
from service as an administrator?
No, sir.
Are you asking this court to name you as the independent administrator, issued letters of administration?
Yes, yes, sir.
I have no further questions, George.
Grant independent administration and authorized letters. Chris, sorry to hear about your dad. Good guy.
Yes.
All right. Nothing
Judge,
else?
may we dismiss?
You may be. Have a good
Yes,
day.
sir. Thank you.
Thank you,
All right,
Judge.
call number 96, the state of Joe Edward Newford.
Morning, Your Honor.
Morning.
Is this Mr. Newton?
Yes, sir.
I'm
It's
testifying.
yours, Travis. And you may proceed.
Thank you, Judge. My name is Travis McCall. I'm personally familiar with Mr. Newton, and I'm familiar with the facts and circumstances surrounding his estate. Mr. Newton passed away on July the 19th of 2025. He had his fixed place of residence in Chambers County on the day he passed away. He had a valid written will dated November 21st of 2022, which I drafted and notarized, and I recognize his signature. As far as I know, he never amended or revoked that will. He didn't leave anything to any state or governmental agency. No children were born to or adopted to him after the date of the will. He never got divorced after the date of the will. The will named Elsie Paul Bork to be the independent executor, and Mr. Bork is not disqualified from serving. He's not a felon or anything like that. And we're asking that the court approve his application to admit Mr. Newton's will to probate and issue letters testamentary.
So done. Thank you, Council.
Thank you, Judge.
Hi, call number 100, the state of Michael Easley. Mr. Fuller, good morning.
Good morning, Judge. May I proceed?
You may proceed.
Your Honor, my name is Roy Fuller. I'm representing the applicant Sasha K. Easley, the surviving spouse of the decedent, Michael E. Easley. The decedent died on October the 26th, 2024 in Harris County, Texas. He was 57 years of age. 4 years have not elapsed since the date of his death. He was a resident at the time of his death here in Chambers County. The original will is dated October the 21st, 2021, which has been filed with the court. And to my knowledge, that will has never been revoked. There is a need for an administration of this estate. There were no children born or adopted after the execution of the will. The decedent did not have a marriage that was dissolved. The will named the surviving spouse, Sasha K. Easley, to serve as independent executor. And to my knowledge, there's no reason why she'd be disqualified from serving in that capacity. The will does not name the state, the governmental agency of the state, or a charitable organization as the devotee. Your Honor, it's a non-taxable estate. We'd ask the court to admit the will to probate and waive the appraisers.
So done. Thank you, Counselor.
Thank you, Judge.
Call number 101, the state of Catherine Brown Franks. She's also yours, Mr. Fuller, and you may proceed.
I'm still here, Judge. Yes, Your
Yeah.
Honor. My name is Roy Fuller. I'm representing the applicant, Rosalie Meyer. She's the sister of the decedent, Catherine Brown Franks. The decedent died on August the 15th, 2025 in Chambers County, Texas. She was 74 years of age. 4 years have not elapsed since the date of her death. The original will is dated March the 6th, 2025, which has been filed with the court. To my knowledge, that will has never been revoked. There is a need for an administration of this estate. There were no children born or adopted after the execution of the will. The decedent did not have a marriage that was dissolved. The will names the sister Rosalie Meyer to serve as independent executor, and to my knowledge, there's no reason why she be disqualified from serving in that capacity. The will does not name the state, a governmental agency of the state, or a charitable organization as a devotee. Your Honor, it's a non-taxable estate. We'd ask the court to waive the appraisers and admit the will to probate.
Counselor. All right, cause number 102, the state of Frank M. Smill.
Morning, Your Honor.
Good morning.
Andrew Riccardi on behalf of the co-applicants.
You may proceed.
Thank you. I'll call Stacy Smeal
I'm here.
first. Morning, Ms. Smeal. Can you hear me okay?
I can.
Could you please state your full name for the court?
Stacy Janine Smeal.
And what was your relationship to Frank M. Schmiel?
I'm his daughter.
And is it true that your dad passed away on August 7th?
Yes, it is.
And was he residing and domiciled in Chambers County at that time?
Yes.
And is it true that your dad left the last will dated August 31st, 2018?
Yes.
And is that the will you're offering for probate?
Yes, it is.
And is it true that your dad never revoked the will?
Yes, that's true.
And no child or children were born to or adopted by him after the date he executed the will, correct?
Yes, that is correct.
And no marriage of your dad's was dissolved after he made the will, whether by divorce, annulment, or a declaration that the marriage was void, correct?
Yes, that is correct.
And is it true that the will names you and Roy Schmiel to serve as independent co-executors of your dad's estate without bond?
Yes, that is correct.
Are you qualified to serve as independent co-executor of the estate?
Yes.
And you're not aware of any reason that you would be disqualified, correct?
Yes, that's correct.
Does a necessity exist for the administration of the estate?
Yes.
And is it true the will does not name the state of Texas a governmental agency of the state of Texas or a charitable organization as a devotee?
Yes.
And is it true that there is no necessity for the appointment of appraisers?
Yes, that's true.
Pass the witness, Your Honor.
No questions.
I'll call.
Call your next witness.
Mr. Schmiel, can you hear me okay?
Yes, I can hear you.
Could you please state your full name for the court?
Roy Maldine Smeal.
And what was your relationship to Frank Schmiel?
I was his son.
Is it true that your dad passed away on August 2nd, 2025?
Yes.
And was he residing and domiciled in Chambers County at that time?
Yes.
And is it true your dad left the last will dated August 31st, 2018?
Yes.
And is that the will that you're offering for probate?
Yes.
And your dad never revoked that will, correct?
Yes. Correct.
And he had no child or children born to or adopted by him after the date he made the will?
Yes, correct.
And he had no marriage that was dissolved by a divorce, annulment, or a declaration that it was void after the date he made the will, correct?
Yes, correct.
And is it true the will names you and Stacy Smeal to serve as independent co-executors of the estate without bond?
Yes.
Are you qualified to serve as independent co-executor of the estate?
Yes.
You're not aware of any reason that you would be disqualified, correct?
Correct.
Does a necessity exist for the administration of the estate?
Yes.
And the will does not name the state of Texas a governmental agency of the state of Texas or a charitable organization as a devotee, correct?
Correct.
Is it true there's no necessity for the appointment of appraisers?
Yes.
Your Honor, this time we request that the last will and testament of Frank M. Schmiel dated August 31st, 2018 be admitted to probate, that Stacy and Roy Smeal be appointed as independent co-executors of the estate without bond, and that appraisers be waived.
Well done. Thank you, Counselor. Your dad was a nice guy.
Thank you.
Right. Thank you.
Thank you.
Cause number 86, the matter of Tyler Ogden. Wayne, Ms. Lane, you on? There
Yes,
you
sir.
are. All right. You may proceed, Counselor.
Yes, Your Honor, I'd like to remind the court that this is an adult incapacitated child or adult Tyler Ogden, who my client, his uncle Joseph P. Ogden III, has been a guardian since starting the process of 2016. In that time, a little history to remind the court, we came before the court last year with 4 probates of a mother, a father who had 1 daughter who was married, and she and her husband adopted Tyler. All 4 deceased, the mother, the father, the daughter, the son, and then now we have the uncle, Mr. Ogden, who has been the guardian since around the end of 2016, 2017. Just a little recap for the court. Mr. Ogden has looked after Tyler, and who is currently at the Jubilee Group Home, and I've had extensive conversations with them yesterday and today, and has an ARC Texas pooled master trust that holds currently $143,885.82 that was invested by the uncle, that is monitored by the state of Texas. Those funds are available for Tyler and are used for extras. We have an application for sale of real property that was from one of the estates. It was brought up in last year's annual report. It's a 4.567 acre tract. Mr. Ogden tried to get a sale of it last year, but that fell through. We now have a sale through Stewart Title, and we have 2 buyers, and they are paying cash of $45,000. When we filed our application, Your Honor, we discovered the annual report is like a week past due. I do have the report prepared with the current balance of the ARC. I have the Jubilee Home and all of their supervisors giving me a report today. They said it should be in by noon. The only thing that would hold back this order, Your Honor, is really, I guess, the annual report needs to be current, but we do have it. It will be provided. In selling this piece of property, Your Honor, it really was a drag on the estate. I mean, it's unimproved property. My client's paid the taxes. He's maintained it, and now we're hitting almost 10 years. So he does have a cash buyer. We had spoken with the court, with you, Your Honor, and had discussed my client has never been paid any compensation since 2016, maybe 8 to 10 years. Let's say 16, around there. He's diligently taking care of this young man who's happy in a group home, activities. Young man receives Spindletop services, group outings, the whole bit. But we're asking this court in this particular sale, my client does not take funds from the ARC. That's specially set aside for only the benefit of Tyler. And it does have almost eventually $50,000. But we would like this sale to be put in a fund directly for the guardian to repay him at a regular price of $400 a month, which retroactively would take most of it, leaving about $10,000 for future, and that's about all he'll ever get. He's a younger man, Tyler, will probably outlive my client, and the trust that my client created through the state of Texas is monitored and will continue on Tyler's behalf. I'm not saying Mr. Ogden's going to pass away, but eventually he will and probably be outlived. But that does support and with interest Tyler. So we're asking this court to recognize the diligent effort of Mr. Ogden all these years That's the only asset we know of to pay him, and for really good services and a structured, continual, consistent support. So we're asking the court that upon the order of approval of the annual report, which I'm going to provide to the court sometime today, that you grant this order that Stewart Title issue the check solely in the name of Joseph Ogden III as a source of payment for the past and the future. At this time, Your Honor, I'd like to call my client. Mr. Ogden? Mr. Ogden, are you there?
You're muted, Mr.
Yes,
Agnew.
ma'am.
Did you hear my kind of monologue for you?
Yes, ma'am. Thank you.
Have you diligently and for consistently, you made sure all 4 probates were probated on behalf of Tyler that he would get the funds to invest in this trust? Is
Yeah.
that not correct?
Yes, ma'am.
And you've monitored and kept an annual account of the Ark of Texas Master Pool Trust in Austin, Texas.
Yes, ma'am.
Is that correct?
Yes, ma'am.
Now, you have, to my knowledge, other than reimbursements out of pocket, you have never been paid for your services. Is that correct?
Correct.
Are you asking the fee of $400 a month, which ends up being like $4,800 a year, to back to about 2017 to be taken from the sale of this real property, and that this check be issued solely in your name as compensation for almost 10 years of effort on behalf of Tyler?
Yes, ma'am.
And in that, there may be some extra funds if you were to add the 4,800 times. Well, I don't know, there may not be, but this is basically, unless you find another asset, where you're at. Do
Yes,
you
ma'am.
understand that?
Yes, ma'am.
But you will continue even if these funds are depleted, to look after Tyler till you're unable.
Yes, ma'am.
I passed the witness, Your Honor, if you have any questions for my client.
No questions, Counselor. I think you did a good job explaining the
Thank you.
situation. All right, I'm gonna approve your order once the annual report is received.
Yes, sir. And Your Honor, I do have it here with the ARC and all the funds that I was talking, it shows the amounts. And the ARC actually sent us, all the actual documents from Austin. And I have the Jubilee report from 3 ladies that have been conferring with me on bringing that report to you.
Okay, we'll get that in and we'll get the order approved.
Thank you, Your Honor, so
Yes,
much for
ma'am.
doing that.
Thank you. And
Thank you,
Mr.
sir.
Howard.
Thank you.
Have a good day. All right, calls number 587, the matter Orville Wayne Perkins.
Yes, Judge, good morning.
Good morning.
Is Mr. Cotton here?
That was all of it?
I don't see Weston on here.
Let us see if we can, Rangeley, will you see if you can get Mr. Cotton and get him on?
Yes, Judge. Ms. Goldberg, Christie actually noticed he wasn't on. So I tried calling him. I left him a message and I sent him a really quick email asking him to call us, and he hasn't called us back. I'm so sorry.
Okay. Well, let's give him a minute
Okay.
to respond.
I'm gonna go ahead and try again.
I had emailed him earlier as well because I wasn't sure if he was on under a different name or not, but I haven't heard back either.
Judge, I'm on hold. It looks like Mr. Cotton was in another hearing that ran much later than they expected. So the secretary is checking to see how much longer before he can join us.
All right, thank you.
Judge, I heard back. It looks like it'll be another 10 to 15 minutes.
Okay, and I'm okay with holding on if the rest of you are.
That's fine with me, Judge.
Yes, that's fine, Your Honor.
Okay.
I want to apologize to everybody for the delay, but I got hung up in a queue at a courtroom and I just couldn't get out very easily.
That's okay. We're all here for you, Mr. Cotton.
We've all been there.
Glad you could join us. All right. So we are on cause number 87, the matter Orville Wayne Perkins. I think everyone's present. Is that Bumholt? Attorney?
Burnett, Judge.
Burnett, okay. I couldn't read my writing. All right, Ms. Burnett, you may proceed.
Thank you, Judge. And just to clarify, I believe it's 587 is the cause number.
Yeah, it is 587. If I said something different,
I called Jessica Drake. Ms. Drake, will you please state and spell your name for the record?
Yes, it's Jessica Drake, Jessica Drake.
Yeah, and we've sworn you in, correct?
Yes, sir.
Okay, you may proceed.
Thank you, Judge. How are you presently employed?
With Health and Human Services Commission.
And in what capacity?
As a guardianship specialist.
How long have you been fulfilling that role?
For about 2.5 years.
And as a guardianship specialist, are you also licensed through the state as a guardian?
Yes, I am.
Okay. And you are the guardianship specialist assigned to Orville Perkins, correct?
Yes, that is correct.
How did HHSC become aware of Mr. Perkins?
He was referred to our program this summer, July 24th.
Okay. And did you complete an assessment to determine his current capacity?
Yes, I did.
What did you find when you conducted your assessment?
He is an individual with profound intellectual disability. At the time, he was getting his nutrition and medication via a PEG tube. And he resides at the Austin State Supported Living Center.
And does Mr. Perkins have the ability to speak? Is he verbal?
No, ma'am.
Okay. And in your evaluation of him, did he appear to be able to meet his own everyday activities of daily living? Okay.
No.
And were there any less restrictive alternatives available?
No.
We're here today asking to be named as the successor guardian for Mr. Perkins, correct?
That is correct.
If Mr. Perkins had actually attended today, do you believe that he would have understood what was going on here today?
No, not at all.
Okay. And physically speaking, obviously we're doing this via Zoom, but would it have been a hardship for him, do you believe?
Yes, it would have been.
Okay. Is it your understanding that the current guardian of the person and attorney ad litem, Mr. Weston Cotton, is in agreement with HHSC being appointed as successor?
That is my understanding, yes.
Okay. And Mr. Perkins does not have a living spouse, right?
Correct.
No living parent?
That is correct.
He does, to your knowledge, have an adult sister, correct?
Yes.
Did you attempt to notify her of this proceeding?
We did. We, go ahead, sorry.
What efforts did you make to try and locate her?
We attempted to locate her via regular and certified mail at 2 different addresses, and both came back to us as undelivered.
Okay, and did you complete an accurate search to get those addresses?
Yes, we did.
And those were the only 2 addresses listed on that accurate search?
Yes, that's correct.
And he, to your knowledge, does not have any other living family, correct?
That is correct.
And obviously, as you've indicated, he's not verbal. He's not able to give you any information about how she might be located either.
Correct.
And Mr. Perkins is currently at the Austin State Supported Living Center, correct?
Yes, he is.
And has the administrator of that facility been provided with notice of today?
Yes, they have.
To your knowledge, is Mr. Perkins' only income Social Security?
Yes.
Now, Mr. Perkins does currently have a guardian of the estate as well as a guardian of the person, correct?
That's my understanding, yes.
Okay. And Judge, at this point, I would just like to point out to the court that I believe Miss Jarrett is still the guardian of the estate, which I think probably needs to be resolved. The motion to remove and appoint a successor was only as to the guardianship of the person. We are not asking to be named guardian of the estate, but I do think the estate probably needs to be closed out.
Oh, will y'all do that?
No, Your Honor, we don't have the resources to be able to do the investigation necessary to close out the estate. But looking back, it looks like the last annual accounting that was filed was in 2023, or it was approved in 2023 anyway. And she noted all zero as far as income aside from Social Security. So hopefully it wouldn't be too difficult for someone to close that out, but we don't have the resources to be able to do that.
All right, Mr. Cotton, will you help us get that done?
I can do that,
You've
Judge.
been on this case. Thank you, sir.
Okay. So HSSC is asking to be named only as guardian of the person, correct, Ms. Drake?
Yes, that is correct.
Okay. And you believe that Mr. Perkins is still incapacitated fully, that he would require the continuation of a full guardianship of the person?
Yes.
And that's as a result of his current mental and physical issues?
Yes, it is.
Is there any expectation for improvement for him?
No, ma'am, not in his mental condition, at least.
Okay. And you believe that it's in Mr. Perkins' best interest that HHSC be appointed as his successor guardian?
I do.
Thank you. I'll pass the witness.
God.
I have no questions, Judge. I am totally in agreement that they should be the guardian of the person of Mr. Perkins.
Thank you, Counselor. Ms. Burnett,
I did file a proposed order that both Mr. Cotton and myself have signed off on, Judge.
okay. Any more testimony?
No, Your Honor.
All right, I'm gonna approve the order appointing only the successor guardian of the person, and that would be Texas Health and Human Services Commission.
All right.
Anything
Thank you,
else?
Judge. No, sir. May we be
All right.
excused?
Thank you. Thank you all. You may be.
Once
you.
again,
Thanks, Your
thank
Honor,
everyone for their
all of the help.
patience.
Yeah, and thanks, Weston, for
Thank
your
you.
help on this as well.
Yeah, thank you, Wes.